So Keemstar just won big money on his fee request for the SLAPP lawsuit that Romeo Lacoste filed against him earlier this year. Let's go ahead and take a look at the documents and see where Keem hit home runs and where he struck out a little bit and talk about what's next. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we're talking about Keemstar and the lawsuit that Romeo Lacoste filed against Keemstar earlier this year, asking for $3.5 million. If you're not familiar with this lawsuit, I'll give you a quick preface as we get into the document, but I'm going to let the court do the explaining on that one, and we will further go on to see why Keemstar was just awarded $142,000 from Romeo Lacoste, where he missed out on some money, and then what is the next step in this process. So stick with me. We're going to go into the documents here. All right. So here's a tweet from Keemstar. It says, Romeo Lacoste sued me for $3.5 million. He lost the lawsuit and the judge ordered him to pay me my attorney's fees. There's a possibility that I will own his tattoo shop. If you would like a free tattoo in the future, please retweet. That is, I guess it's theoretically a possibility, but that's not the focus of this video here. We have this document. This is the order from the judge on what is to happen with this fee request. Now, a little bit of background on this is provided by the court. Plaintiff is a celebrity tattoo artist. That's Romeo Lacoste, who brought the lawsuit against the defendant, Keemstar. Defendant operates a YouTube channel that reports on breaking news about social media influencers and internet celebrities. Defendant has accused plaintiff of pedophilia in several videos across YouTube, Twitter, Instagram, and Snapchat. Plaintiff specifically lists 3 videos defendant uploaded to YouTube on March 16th, 17th, and February 10th. In the February 10th video, defendant interviewed a minor who allegedly had conversations with plaintiff. Defendant has also said that plaintiff and his career are finished and that plaintiff belongs in a cage. The accusations against plaintiff have caused substantial damage to plaintiff's business from an aggregate loss of a mass of individual clients. Defendant was acutely aware of the nature of plaintiff's business and the potential impact of his statements, and there was additional loss from employees deciding to work elsewhere. These losses directly correlate to the videos defendant created and publicized. That's the factual background. But the procedural history of this case is interesting because in the documents that Romeo Lacoste himself submitted to the court, he admits to the accusations. So between his admissions plus evidence that Keemstar was able to provide, including interviews, transcripts of YouTube videos, and transcripts of interviews that he had with some of these alleged victims of Romeo Lacoste, that was enough for the court to say, but you did it though. Like, you may have sustained damage, but you did the thing that he's accusing you of doing, so this isn't a defamation case. So because of that, Keemstar filed a motion, basically what's called an anti-SLAPP motion. And that is a motion that is to dismiss a strategic lawsuit against public participation. Lots of states have anti-SLAPP provisions. California is one of them. And basically what happens is there's a pretrial motion that says, okay, here's what happened. This lawsuit is frivolous because my opponent has no way of winning. He's only bringing this lawsuit to prevent me from speaking publicly. And it became very clear from the outset that that's what Romeo Lacoste's intention was, from the posture that they took in sending a cease and desist, and then from going ahead and admitting to all of the underlying facts in the documents that were submitted to the court. They went ahead and sealed their own fate. So the only thing we had left to do was to determine how much money Keemstar would be able to take from Romeo Lacoste. Since the person being sued in a SLAPP suit has no other remedy, they have built in the idea that you should be made whole on your attorney's fees and any costs that you are incurring in the suit as a result of the SLAPP nature of the suit. Now, it doesn't mean you can inflate costs and get all of them back. You're only entitled to what is reasonable under the circumstances of the case. And that's what the court is going to analyze here. But let's get to the meat of this thing right away. Defendant requests attorney's fees of $169,875 and non-taxable costs of $8,962.51. So Keemstar is asking for almost 180 total thousand total dollars to go ahead and defend this case. Lawsuits are expensive. Lawsuits in federal courts are really, really expensive, especially when that lawsuit takes place in LA and you have lawyers whose fees are relatively high. We'll go ahead and talk about the fees that were submitted. The court has discretion to adjust the hourly rate based on the following facts. So we've got a couple factors that need to be considered to determine how much the prevailing party, Keemstar in this case, was entitled to. And that is, what are the rate of his attorneys? How many hours did they spend on that, on the documents on the case? And is that reasonable? And then once they determine that, they move on to costs. What were the costs incurred? Were those costs related to the lawsuit appropriately? And should they be compensated? So first, we're going to look at the hourly rates. The court has discretion to adjust the hourly rate based on the following facts, assuming they were not already subsumed in the lodestar calculation. Now, a lodestar calculation is where an attorney goes through and looks at the itemized bill that he's generated, and he basically pairs out any unnecessary work, and he shows the amount of reasonable hours expended on the suit, and then he multiplies that by his hourly rate. And if there's any supporting staff, other attorneys, paralegals, legal assistants, anybody else who was paid to prepare this, to prepare documents and to present the case, they would also be included in that lodestar at their rate for the hours that they worked. So that's what the lodestar calculation is. So the four factors that the court considers are: 1, the novelty and difficulty of the questions involved; 2, the skills displayed in presenting those questions; 3, the extent to which the nature of the litigation precluded other employment by the attorneys. So if they have to take an emergency case that's really big and takes up a lot of time, and if it's a small firm, for example, they might have to put off other work. That's what they're looking at there. And 4, the contingent nature of the fee award. So contingency, if they're taking the case on a contingency or not, matters whether the in how the calculation is considered and what reductions need to be made. A contingent fee award is you won't pay unless you win, or you'll pay a little bit, but any remaining amount will be on us unless you win, and then we will take a percentage of the winnings and stuff like that. So we'll keep moving on. Here, though, the defendant supplied the following rates, so you can start to see why this is such an expensive suit. Eric George, $900 an hour. Kem Zeldin, $600 an hour. Eric Westland, $450 an hour, and then the paralegal Ann Kim at $150 an hour. This is what is billed to Keemstar, and we can see that there are a ton of hours coming up that were expended on this. That's in the next section. The court found that based on the submitted materials, the court's review of the 2018 real rate report, and the court's familiarity with the local market, that the requested rates for all 4 people are reasonable. This is just how much lawyers for federal lawsuits in LA cost. So that's what's going on there. All right, so as for the hours expended, here's where we start to see Keemstar lose a little bit of his request. And I must point out that this is pretty typical. You're going to see judges exercise discretion when they can and remove at least some portion of the fees. It makes it a little bit harder to appeal the fee decision if the judge makes some reductions to it. And in this case, the reductions amount to about on the hours expended about 10 to 15%, I believe. It's lawyer math, so I might be wrong. But you guys can check it out. Okay, so fees and costs unrelated to the anti-SLAPP motion are not recoverable. So here what they're doing is the court is reviewing the hourly itemized work that was submitted from the invoices from Keemstar's attorney, and they're determining whether or not the itemized work is sufficiently recoverable under the statute. So in this case, fees and costs unrelated to the motion are not recoverable. And then the fee award may not include fees that would have been incurred regardless of the anti-SLAPP motion. So if you're doing other stuff, like if you're fighting service of process, or you're saying there were some procedural defects that happened that are unrelated to the anti-SLAPP, you don't get to recover those. You just get to cover stuff related to the motion. Now, this is naturally going to entail work that you do on the main case, because you do still have to, you still have to research the documents, you have to research evidence, you have to go ahead and compile things and put together arguments that are relevant to the underlying case, but they're also relevant to the anti-SLAPP motion specifically. And so those are going to be recoverable. If they're not relevant to the motion, those are not. So here's where we'll see some reductions. So the counsel for Keemstar purportedly spent 307.8 hours on the motion. That's a lot of time. That's a lot of time. And that's, again, why this gets so expensive so quickly. And they spent 31.6 hours on the reply to the fees motion. So they've got a bunch of stuff in trying to, prosecute the case. That's the initial 307.8 hours. And then they have to spend another 31.6 hours on the request for fees itself. And so that continues to increase the cost. The court finds that many of the itemizations sought by defendants are reasonable. However, reductions are necessary. Now, I'm not going to go through the individual reductions, but these are the things that the court found needed to be deducted from the itemized invoices that were provided to it. So I'll, put this up for a second. You guys can pause the video if you want and take a look at those individual line items. There's some more down here, and then resume when you're done. So after deducting these itemizations, the total requested hours is reduced from 339.4 to 305.9. That's them taking those two figures from before and combining them together. But now they're reducing it to 305.9 hours. But that's not all that they are going to lose out on here. Some of the work, the court finds that some of the work performed by the defense counsel was duplicative and excessive. And so therefore, the court is finding that duplicative and excessive work is unreasonable. Remember, you're only able to recover reasonable attorney's fees. So if you're doing the same thing, or if you have two people doing the same thing, some of that work is duplicative and it doesn't need to be billed twice. And if you're spending too much time doing something basic, the court's going to determine that to be unreasonable and reduce it as well. And they do that in several individual areas, taking off a couple hours here and there. One of the more egregious ones that the court had was here. Westland and Zeldin spent 12.4 hours on the 6.5-page fact section of the anti-SLAPP motion. So that's 2 hours a page, right? Given the length and complexity of the facts section, the attorney's experience, and the fact that Kim appeared to have already extensively investigated the facts of the case earlier, the court finds that 12.4 hours are excessive and concludes that 6 hours are reasonable for the task, 3 hours for each attorney. So remembering that all of these tasks that they're doing are building up as they go, and they symbiotically feed off of each other and inform the rest of the case and reduce work that would be done elsewhere. So here you have a big reduction. I mean, the court is taking away 6 hours of work, 3 from each attorney. 3 hours from Westland is something like $2,700, and 3 hours from Zeldin is another $1,800. So you can see why the court has an interest in reducing unnecessary work being billed, because these measures are not punitive. It's not punishing Nico so much as it's trying to make Keemstar whole. So the court doesn't want to get into this idea that the fees are there to punish and therefore we should have excessive fees. If the fees are excessive, they're excessive, and purportedly Keemstar will be able to work out those excessive fees with his counsel and say, well, the court concluded they're excessive. Maybe they want to renegotiate. I'm not saying they will do that, but that's the idea. If it's excessive, the court isn't going to award it just because someone lost a suit. All right. So the court, after doing all of its reductions, further reduces the hours from 305.9 to 275.3. So now we've got all of their rates and then a total amount of hours of 275.3. Now, it's of course going to be partitioned out to the individual rates for the individual attorneys. But multiplying the 275.3 hours by the reasonable hourly rates of George, Zeldin, Westland, and Kim, respectively, generates a total of $142,095. And I'm just realizing now that Westland was the associate attorney, so 3 hours of his work is not $2,700. It's about $1,350. $1,350. Yeah, my bad. Sorry about that. Moving on though. So this is the award. $142,095 is what's awarded on the fees section of this. So now the court will move on to the costs. And this is where they missed out big, but it's not the end of the story for Keemstar's attorneys. So the defendants request the following costs, which total just under $9,000. Now they have Westlaw Online Research, and they have RELX Online Research as well. That's LexisNexis, which is another legal research tool that's available. So they have several $1,000s in research fees, but what they missed is laid out by the court. It says the court finds that the defendant has not satisfied its burden to show that the requested costs are reasonable because it did not submit evidence on how the attorneys in the legal community charge for Westlaw and Lexis use. So they just said they have these fees, but they didn't say why they have these fees, how these fees pertain to the court. For example, in my billing, most of my research tools are done on a monthly basis, and that's factored into my hourly rate. That's just a sort of a cost of doing business for me. Now, if I have to research outside of my normal plan on a particular issue, I would then incur additional fees, or if I had to upgrade my subscription, that might, for the purpose of the lawsuit, that might go ahead and be a fee that would not otherwise be included in my hourly rate already. And so what they didn't do here is explain any of this. They don't explain what justifies these fees other than or outside of their normal working amount. So the defense counsel did not supply the court with the firm's Westlaw and Lexis fee arrangement or otherwise explain how they arrived at the requested amount. So that's the other problem. They didn't say what the billing is for. Is it a per page billing, which is available on Westlaw? Is it a monthly fee that they do, and this is multiplied out based on their subscription types and the amount of months that it was? They just didn't lay it out. So the court denies the defendant's request without prejudice. The court here is actually leaving the door open because the law does entitle Keemstar to costs. The court is saying, okay, you have a little bit of extra time to go ahead and justify these because the court isn't finding them unreasonable. The court isn't finding enough evidence at all to support the fees in the first place. So the court wants more information on that. The conclusion, the court grants in part the defendant's motion in awarding $142,095 in fees. It denies without prejudice the request for costs, and any renewed motion for costs must be filed within 14 calendar days of this order's issuance. So Keemstar now has 14 days to go ahead and modify or amend or further request a fee award, or a cost award, I should say, for that roughly $9,000 of costs that were incurred allegedly as part of this suit. They'll just have to justify it, and the other party will have the opportunity to argue against it. But right now, there's not enough evidence included. But it is a big win for Keemstar, but there's a big asterisk on it as well. And that is that Romeo Lacoste has appealed the decision in this case, which is going to put most of this stuff on hold. Now, I believe in California that Keemstar can pursue collection of this amount. However, Romeo Lacoste may be able to delay the collection of this amount pending the outcome of the appeal if he does something called putting up an appeal bond. And that's where he gets a bondsman to go ahead and put up the money to the court at a percentage base that he would put down, and then the bondsman would guarantee the award so that during the appeals process, he's not depleting all of his funds and making them unrecoverable for Keemstar. Court doesn't actually want that to happen most of the time, so they will sometimes require a bond amount to go up. But during the appeal, if Keemstar is able to pursue this, Romeo can probably defray that with a bond, but we'll have to wait and see how that pans out. I think the appeal is ill-fated and likely to fail again, simply because of just what Romeo admitted to in his initial documents and in all of the documents that he's filed in this case. It really seems that that he's alleging defamation, but did everything he's saying was a lie. So not really a very effective way to argue defamation, but, you know, to each their own. So that is how Keemstar won big and lost a little on this case, although his losses both have, both his win and his loss have asterisks. Of course, this is on appeal, so none of this really will play out until the appeal is done for the most part. I mean, it's possible to pursue it in the meanwhile, but there's mitigation that can be done by Romeo Lacoste for the fees in the meanwhile. The asterisk on the loss is that he does have 14 days to resubmit it, and if they really want to go after that $9,000, they can do it. They just have to provide the court with enough facts to make its determination. So there you go, guys. Big update on the Keemstar case, and I like to keep you guys posted on cases we're watching. Thanks. If you like this kind of content, please like, subscribe, share, do all of the things that the internet does. And if you want to keep following this case as the appeals go on, stick around and we'll watch it. Thanks a bunch. Have a good day. Peace. Peace.